Good morning. Happy Monday. There are two attorneys that I really enjoy watching on the internet, on YouTube. One is Robert Barnes of Barnes Law, and the other one is Uncivil Law, whose name I unfortunately don't remember, but he's a character. They're both characters, they're both unique individuals in their own way. Robert Barnes is the consummate trial attorney. He can talk for hours about the same thing. He will repeat himself ad nauseum. He will blow past any time constraints. He loves to hear himself talk. That's what trial lawyers do. It is one thing that I'm actually not very good at. I'm not practiced enough at doing that yet. I tend to be very succinct. On the other hand, Uncivil Law is very intellectual. He thinks about the law. He understands the law. He has a very nuanced understanding of the law. He's got a lot of intelligence, a lot of facts at his command. I think both of them are excellent lawyers in their own way, and I very much appreciate both of them. And as a first-year family law attorney, I don't dabble in the federal as much as they do, not nearly as much as they do. I've been an attorney on relatively few federal cases, but I'm sure that they have done quite a bit more. And so I enjoy watching them and learning from them. Well, in the Viva Fry stream on Sunday night, just yesterday, Robert Barnes made the rather unnuanced statement that lockdown orders are unconstitutional. Now, trial attorneys will often make statements like that because a trial attorney's goal isn't so much to educate the jury, it's to convince the jury. And Robert Barnes is a very convincing person. That's who he is and what he does. He is, like I said, the consummate trial attorney. Well, being the more intellectual, willing to grapple with the finer points of it, this apparently upset Uncivil Law, who on his own stream later last night took exception to Robert Barnes making such a blanket, unnuanced statement. And, he's right. I mean, you have to look at what the actual lockdown order says and why it says it, and you have to take into account all the various aspects of it before you can kind of give a prediction on which way a court's going to go. And even then, you never know, because courts have made some weird, dumb decisions like Wickard v. Filburn, where grain that you grow for your own consumption it affects interstate commerce, and therefore Congress can reach it, which is weird, absolutely weird. If you have a vegetable garden in your backyard, presumably Congress can reach that and regulate how many carrots you grow or how many tomatoes you grow. Anyway, that's not the point. We're not talking about Wickard v. Filburn. We're talking about lockdown orders. So Uncivil Law starts talking about quarantine, and quarantines are, I agree, the best kind of analogy to lockdown orders. But quarantines are different. There's two basic kinds of quarantine. There's the quarantine where we don't know what you got, but we think you have a disease that's really, really bad. And it's a really, really bad disease that we've kind of figured out is really, really bad. And therefore, we're going to hold you for a period of time to determine whether or not you have that. And usually it's just until they can get the test results back, or for a shorter period of time if possible. You can see that in Hickok v. Christie, which is a case that I talked about before. There's also US v. Skinner or something along those lines. I forget them all. There's California cases on it. There's that Jew Ho case. There's In re Martin. There are a variety of cases on it, but typically what that initial kind of quarantine is for is to determine whether or not you have something. The state has probable cause that you have the thing or that you've been infected by it. So in Hickok's, she was volunteering as a healthcare worker in the the Ebola crisis in Africa. She came back to New Jersey and boom, quarantine, because she had been dealing with Ebola patients, and so they had probable cause that she had Ebola. In re Martin, they had probable cause because of because of, at the time you could quarantine for oh gosh, what was it? Syphilis, I think it was. Yeah, I think it was syphilis. These gals were known prostitutes. They were in a house of ill repute. There was an epidemic of syphilis going on, so they had probable cause for holding these gals until they could determine whether or not they had syphilis. So that's one kind of quarantine. Then there's another kind of quarantine that's the more long-term quarantine. You see that at least in California with tuberculosis. Tuberculosis, as most of you are probably aware, is it's airborne. So, people coughing can spread it, and people can be asymptomatic with it. Sound familiar? Probably should. Anyway, if you are known to have tuberculosis, they may quarantine you. As long as you're taking your drugs, they'll let you out into society, because the drugs will keep the tuberculosis below a point where it's contagious. But then if you refuse to take it, then they can get a court to intervene, and they can actually quarantine you for a longer period of time. How long that period of time is, I don't exactly remember, but they can quarantine you for a considerable length of time for treatment, I suppose, or at least to get treated to the point where you're no longer contagious again. And as long as you agree then to stay on your meds, then they'll let you go, or at least that's my understanding of it. So quarantine is very similar to the lockdown, but there is a huge difference. In a quarantine, there is due process. They have it's a Fourth Amendment issue. You can't seize somebody without, there's a prohibition against unreasonable searches and seizures. So a seizure, if you seize someone, it has to be reasonable. So if you are going to confine someone, for example, to their house, it has to be reasonable. And the metric that they've used, like the Department of Health and Human Services, they believe that the wording of their quarantine, they're the Federal Department of Health and Human Services, they believe that the wording of their quarantine requires their quarantine inspectors to have reasonable suspicion, or probable cause before they can quarantine someone. They think that they actually meet the probable cause standard. Whether or not they do is entirely a different story. Except for borders, like quarantining ships coming in, quarantining people coming in, but bringing stuff into the country is different, because the Supreme Court has held that your rights as an American citizen are at their least crossing the border. The government's interest is so overwhelming that your rights are somewhat diminished, and so if you come in, they may need less than probable cause to hold you at the border. Anyway, I wasn't meaning to go there. My point is that there is an amount of review that you can get in a quarantine. If you believe that you have been quarantined in violation of the law, if you believe you've been unreasonably seized, then your remedy is to petition for a writ of habeas corpus. And then you get your hearing in front of the judge, and the judge, I believe it's preponderance of the evidence. You have to prove by preponderance of the evidence that it was an unreasonable seizure. But I could be wrong on that, because I actually haven't really researched that, so you'll have to forgive me, but I believe it's preponderance of the evidence. And then it shifts the burden to the government, and then the government would have to prove their portion. I think that's the way it is. I'm probably wrong on that, so don't hold me to it. I'd have to look it up. But my point is that there is due process there. There is a burden of proof on the government to seize you for a quarantine. It's for a specific period of time, either until they determine whether or not you're sick, or until they get you past that contagious point of being sick. So it's a definite thing. Now, lockdowns are entirely different, obviously. Lockdowns may be where you're confined to your house. When they first issued the lockdown orders, I believe in California, if I remember correctly, you could only go to work if you were an essential worker, or you can go to get basic necessities like food and water. So those are the two things that you could do. Now, it was implemented entirely backwards, where, places like Walmart and stuff like that, where they sold food and other things, were allowed to be open. I believe liquor stores were allowed to be open. I mean, it was completely weird and wrong, but that was the general idea. So you're being seized, you're being confined to your house, with a very small amount of liberty, without any specific end goal. Because, as we all know, 15 days to slow the spread has turned into 6 months to slow the spread, or something like that, with no real end in sight. There is no end in sight. So lockdowns are different than quarantines. All right. So now we've established that. So Uncivil Law's position is that at the beginning in March, the lockdown order was an unqualified constitutional. And I take some exception to that. I take exception to it because the general test, it depends on exactly how the lockdown works and everything like that. But if the lockdown prevents you from interstate travel, or if it prevents your freedom of assembly, there are tests in place, either intermediate scrutiny or strict scrutiny, that place the burden on the government to determine, or to prove to the court that they are justified in making the law. So the intermediate scrutiny test is it has to be a significant or important government interest. And sure, a strange virus that we don't know about is a significant or important government interest. The health of the population is a significant or important government interest. It's probably a compelling government interest, but it's at least significant or important. And then what the government has to do is they have to narrowly tailor their response to achieve that significant or important government interest. And so that what they would have to do is they would have to show that what they're doing isn't overreaching into other areas, that it's narrowly tailored enough. I mean, the language is the language, that it's not overbroad. It's not going to snatch up liberties and rights and freedoms that it doesn't need to accomplish those goals. Of course, if you get up into the strict scrutiny analysis, which I believe you could well do, especially with First Amendment issues, freedom of assembly, then it would be a compelling government interest. Again, an unknown virus coming into the country, that is a compelling government interest, especially when the government is aware. But then it has to be, again, narrowly tailored, but it has to be the least restrictive way, the least restrictive method of achieving that compelling government interest, protecting the public health. Now, what Uncivil Law was saying was the government doesn't know, so they're going to get carte blanche, because the government didn't know back in March the severity of the virus. They didn't know back in March whether or not the virus would do better or worse by quarantining people, by forcing people to stay indoors, or by letting people go outdoors. They didn't know if the virus, how it was spread. They didn't know how long it could survive on surfaces. They didn't know all these things. So according to Uncivil Law, the court's just going to allow them to do it because the government doesn't know. But the problem is it's the government's burden to prove that their law is narrowly tailored and the least restrictive means of achieving that goal. So the government's going to have to show something. They're going to have to put an expert on the stand that's going to say, hey, yeah, this is the best way to do it. There is no less restrictive alternative way of doing it. And obviously, the opposing counsel is going to say, well, what evidence are you basing this on? I don't remember if the federal government uses Fry or Daubert, but there's, it has to be tested. It has to be accepted within the community. There's the error rate they have to look at. It's tapes. I forget what P and S are for. I don't really care right now. But essentially their experts come on it and give the basis that he's making this claim on. And if his whole position is we don't know how the virus works, how the virus spreads, whether it does better at spreading indoors or outdoors, whether or not the lockdown is going to be effective or whether or not it's going to make it worse, whether or not people need extra vitamin D and extra sunshine, we don't know. If the government's position is that we don't know, then they can't carry their burden of proof. So my contention is that it would actually be less likely that the lockdown order would be constitutional back in March, because it's the same facts. It's just whether or not the courts are going to step in at that point. Now, that said, the courts seem to have a method for dealing with this, because nothing in the law moves fast. So the first thing that happens is someone's going to file for a preliminary injunction or a temporary restraining order. That's probably not going to make it. But then you're going to get that full hearing, and it's going to take time. There's going to be extensions and delays. I am absolutely shocked that Stickman got to his decision in Pennsylvania in less than a year, because in my experience, being a first-year family law attorney, a lot of civil cases take a year or two to get to their ultimate resolution if they don't settle. I mean, if they settle, obviously they can get done quite a bit earlier, but usually it takes a year or two. And I can imagine with something as complicated as a virus, and with the government trying to delay things to get evidence in place to support their position, that it would take even longer. So there is kind of a administrative hurdles in place towards the law being found to be unconstitutional quickly, but that doesn't mean it wasn't unconstitutional to begin with. So maybe I'm just overly into the nuance on it, but I just have to disagree with Uncivil Law's unnuanced yes. In March, the lockdown order was constitutional, because again, the government can't carry its burden without having that information. The government needs the information to carry the burden. Without the information, it can't carry its burden, and therefore the court would have no choice but to say, well, it's unconstitutional because you couldn't carry your burden. And that doesn't mean that later on, with more evidence, the government couldn't come back and institute a lockdown order. But again, and I think lockdown orders, I do believe, because they infringe on so many rights, especially if you're limiting, if you're requiring people to stay inside, like from what I understand in New York, they're requiring people to stay in their apartments and homes pretty much all the time, with very limited exceptions. That infringes on so many rights. I can't imagine that it would be anything other than strict scrutiny. The nature of the virus, the nature of the disease would have to be so compelling. I understand that 200,000 people have died, and that's a travesty, and that's terrible. But I don't think that's the kind of thing that we should give up our Constitution over. I don't think that's the thing that we should give up our rights over. 200,000 people is terrible, but that doesn't mean that we should just waive all of our rights because there's a bad disease flowing through. I mean, there have been bad diseases before, there'll be bad diseases again, and humanity will shoulder on. Anyway, I've rambled long enough. Thanks for watching. Have a great morning.